Hello and welcome to tonight's program, Estate Planning 202, Estate Planning with an Eye Towards Health and Incapacity. We're joined tonight by Brian McAvoy. Before we get started tonight, just a quick word about how it's going to work. Brian's going to present for some time, and in the middle of the presentation and then again at the end of the presentation, he's going to take questions from the audience. So if at any point tonight you have questions, feel free to throw them in the chat box or in the Q&A box. Now, in the past when we've hosted Brian, some people have gotten very specific with their questions and their personal situations. Please remember that Brian is a lawyer, but he is not yet your lawyer. So he's here to answer broad questions about the topic at hand, and he may decline to answer questions that are too hyper-specific about a certain scenario. I also, before we get started, want to thank the Friends of Duncan Library for hosting tonight's program with their Zoom account. They pay for the Zoom account so that we can host Brian and other presenters in a webinar environment that Zoom bombers cannot interrupt. So I just want to say thank you to the Friends of Duncan Library. If you like this program, if you like the programs I've been putting on using Zoom, consider becoming a friend of Duncan Library. You can do so for as little as $25 a year, and that money goes directly into Duncan Library's programming budget and their book budget. So it's a great way to support your local library, and most people renew their memberships every fall at our fall book sale, but this year we won't be having a fall book sale because of COVID-19 restrictions. So if you are a member of Friends of Duncan Library, don't forget to renew that membership this year. So just thank you to them, and thank you to you for being here tonight on a random Thursday night to talk about this subject. At this time, I'd like to introduce our speaker. Brian P. McAvoy is an associate attorney with the Smolin Levy Law Firm. He is a member of the bars of Virginia, Maryland, the District of Columbia, and Massachusetts. He is a graduate of Boston College and Howard University Law School of Law, where he was a Marshall Brennan Fellow and was recognized as the best advocate for his work in the criminal justice clinic. Brian began his legal career as a criminal appellate attorney, founding his own practice after his judicial clerkship on the District of Columbia Superior Court, where he won several noted reversals, arguing before the District of Columbia Court of Appeals. When he and his wife welcomed their first daughter, he shifted the focus of his practice to estate planning for families with young children like his own. He carefully tailors each estate plan to the needs and goals of his clients as if for his own family, and he views each estate plan as a unique and different plan. Brian's practice areas include estate planning and estate agency.
Anna, I'm very sorry. We're having a little bit of sound trouble.
Oh,
that's better.
Okay, I'm sorry about that. My connection must have went out for a second. I apologize. Brian began his legal career as a criminal appellate attorney, founding his own practice after his judicial clerkship for the District of Columbia Superior Court, and won several noted reversals, arguing before the District of Columbia Court of Appeals. When he and his wife welcomed their first daughter, he shifted the focus of his practice to estate planning for families with young children like his own. He carefully tailors each estate plan to the needs and goals of his clients as if for his own family, and he views each estate plan as unique and different. Brian's practice areas include estate planning and estate administration, and he engages in information seminars and presentations on trusts and estates throughout the region. Please join me tonight in welcoming Brian McAvoy.
Thanks so much, Hannah. Well, I really appreciate it. I appreciate the Duncan Library, where, as you heard a little bit about, my wife and I have two daughters, and the Alexandria City Libraries have been a real source for us. And I thank Hannah in particular, and I thank all of you for joining us tonight. As you might have seen by now, the little icebreaker here on the welcome page. You might have heard me say already, but I'll say again, this is not just a way for me to get recommendations for where I can get good takeout, but I will tie it into the presentation as well You won't have to share it with the class, as I said, but it will tie into the presentation. In fact, in particular, it says, what's your favorite restaurant / takeout? I'd like you to envision a restaurant, a sit-down restaurant, a little bit more back to that normal that is getting a little hard to remember at this point, isn't it? But in part, I kind of try to take the philosophy that we are dealing with a challenging topic here, a topic that's difficult to think about and even difficult to talk about sometimes. And I want to try to cut that with a little bit of humor, a little bit of thinking about a more relaxed setting, and to kind of take on the difficult topic in that manner. So if you can, envision that restaurant you like going to, and we'll tie that in. All right, well, the other thing I want to talk about with respect to a challenging topic, and if you're here, it's because you have questions about it. If at any time you are getting a little overwhelmed by a tough topic, the way that we like to think about it in the estate planning world is it's always better to have an affirmative plan to not only envision how you would want things to go, but also to tackle that difficult topic with an affirmative plan in mind. And with that, let's start to talk about those topics. Well, here is that first slide. Oops. You're going to see plenty of pictures of my daughters. Sage on the right, Morgan on the left there. And I'll give a little bit more on that background. Hannah gave a little bit of my bio, but I actually went off to law school to be a constitutional litigator. And we all get teased about that. Oh, you think you're going to argue the Constitution. Really, it's just going to be contracts and that kind of thing. Well, actually, no. I did get into criminal appellate law before the DC Court of Appeals, was able to quote the Federalist Papers, Hamilton and Madison, and I did quite like it. But about 8 years ago, my wife and I welcomed our first daughter, Sage, and not far behind was Morgan. I did warn you that you're going to see pictures of them. Well, here they are, our two beautiful girls. And my wife turned to me and said, well, I know that we probably need, I don't know, wills, guardian nominations, something. You're the lawyer, go figure it out. And sure enough, that's what I did. I hit the books that I had saved from law school, started researching, and put together the very first estate plan that I would put together, and it was ours. And I have refined it since, but that was my start. I was a solo attorney at the time. Since I have joined Small and Plevy and also do estate administration, but that was how I got my start. And the same point that I just made about tackling a difficult topic, of course, my wife and I were thinking about what happens to our girls, what happens to our belongings, what happens if something happens to us? And that's the core question. In fact, we can kind of divide that question into two. What would happen if something happened to you? And there are the two divisions, in the short term and in the long term. Now, tonight we are doing sort of our follow-up presentation to an earlier one, but if you didn't sit in on our Estate Planning 101, don't worry about it. I'm going to do some recap and touch upon a lot of those topics as well, but we are going to speak a little bit more toward that first point. What happens in the short term? Meaning something has happened to you, you haven't passed away, but you are incapacitated. You can't tell us what you want to have happen to your assets, to you and your health, And here, as you might know, we're probably talking about powers of attorney, but I'm going to talk about how there's more to it than that. And then we're going to talk a little bit more about, in the long term, we're going to talk about what does happen after you do pass away, and what are the either the documents that come into play, or we'll talk a little bit about probate and or trust administration. And if some of these things you don't know a ton about, well, that's why you're here, right? So no worries, we will talk about it all. Right up front, the documents during your life, powers of attorney, both general and healthcare powers of attorney, are the documents that we would assemble along with an advanced directive, or an advanced medical directive, or living will is what you might hear it termed as. And so we're going to talk about those documents, what they are made up of, what they can help to do, what some limitations might be on those documents, and where they come into play. First, the healthcare power of attorney. I want to, actually, let's back up one slide here, the documents during your life, and let's call back that scenario that I was talking about in our little icebreaker. Pause for a moment here, call to mind that restaurant. For me and for my wife, it is Hank's Oyster Bar. Somebody please tell me in the comments, that's still open, right? Gosh, that would break my heart. That's our favorite date place. I'm just going to move along assuming that Hank's Oyster Bar is hanging in there. Okay. My wife and I have somehow lined up a babysitter, hard as that is, and we are out for the mommy daddy date at Hank's Oyster Bar. And yes, if you were at Estate Planning 101, I'm going to use the same scenario. There is a traveling salesman who goes from dentist to dentist selling that sleeping gas. And he has brought one of those canisters in. He's been delivering the canisters to the dentist. It's been a long route. He stops at the bar to get a drink. One of those canisters falls over, leaks sleeping gas throughout little Hank's Oyster Bar, and everybody falls asleep. And a nice deep sleep too. And for any of you that are parents as well, this actually sounds kind of nice, doesn't it, right? Finally, I get some sleep. Well, that is good on one hand, but on another, remember our question: what happens if something should happen to you? There are, in our case, children at home, and hopefully there aren't any health side effects from this, but we would like to have something, a plan to say what happens to us, what happens to our belongings, what happens to our children if something happens to us. So that first document would be the healthcare power of attorney. Who makes decisions about your health if you cannot voice those decisions yourself? The healthcare power of attorney grants limited powers to your agent to give voice to your health decisions. That's often going to operate in concert with your healthcare directive, your living will. Sometimes those documents will actually be joined into one document as well. Before I go too far, the living will is essentially, and this did get some publicity not too long ago in the Terry Schiavo case. A living will is a document giving wishes to what procedures you would or would not like to have happen, what life-sustaining measures you would like to be administered, and more specifically, which ones you would not. The healthcare power of attorney is springing in nature by its very definition. What does that even mean? Well, It does not come into play until and unless you are incapacitated. The document itself is going to define that, and it's going to say that these powers are not given to the agents that you have named until and unless you are incapacitated. And this power only exists during your life. Perhaps that's self-evident when you really think about it, but sometimes when we think about an estate plan, and this was in the description that I think we listed, we think about, well, what happens to our things when we pass away? Well, actually, a full estate plan speaks to much more than that. And in fact, the powers of attorney speak really only exclusively to what happens to you during your life. And that's where this power comes in. The next document is the general power of attorney, and it's sometimes called the financial power of attorney. We do not call it that because, in fact, it's actually a much larger power grant than just control over your financial assets. Now, existing versus springing power of attorney. This document can be either. It can be written both ways. It can give power to your agent right now at signing. Now, this can make people a little nervous. Wow, I've really, just by signing this document, given power to these people listed to have control over my assets. Well, yes. And in fact, if you have concerns about the folks that you've listed in this document and whether you can trust them, let's perhaps do a little more thinking about whether these people should be given that power, right? And in fact, attorneys will often advise, especially if there are some existing health concerns, and if this power of attorney is being put together with that in mind, an existing power of attorney is actually a very good idea because, well, sometimes we don't know when we are all of a sudden going to need to call this power of attorney into play. And in fact, it can enter a bit of a gray zone. Is this person incapacitated? If anybody has experienced a loved one in declining health, particularly in declining mental health, that can be a very, very difficult time. And to be able to have an existing power of attorney where somebody has a document that can be relied upon to change assets from here to there, to be able to move assets for perhaps health support or any other reasons, that's a very, very strong and powerful tool to have that be existing. They can, though, be written in springing fashion, meaning this power does not come into play until and unless I am incapacitated. Here we largely define that already, but it grants power to your agent, the people listed, control over your assets, belongings, even property, meaning real property, like real estate. However, we are right now going to start speaking to the limitations on this document, in particular with respect to that last point there. Again, this only is in effect during your life, and it's not always respected by institutions. What do I mean there? Well, this document can and often does have language empowering the agent to sell real estate, but it's very, very rare that institutions, a title company, a buyer will take a look at a power of attorney and say, yeah, I can rely upon that. It is the type of thing that, sure, a transfer from a bank to a person that or an institution that needs a payment from that bank is one thing. To move real estate, we are much more likely going to need a specific real estate power of attorney. Pardon me. Additionally, if this power of attorney is either too old, it's been written too long ago, an institution might get a little nervous and say, well, has it either been updated? Is this a person that would still be given this authority by the signor? Or on the other hand, if it's too recent, we might be thinking, was this done in light of declining mental health? Did the person have capacity to sign it? And so it's a very, very necessary tool, but it might not always be enough to do what we want it to do. We will not let somebody walk out of our office without it, but we're going to speak to either the limitations of this or other ways that we can achieve those goals. With that, I believe, Hannah, I think we are at a good point to perhaps take some questions, whether they have already been posed or if folks want to start firing them off at this point.
We don't have any written questions yet, but if you have a question in the audience for Brian, feel free to put that in the chat box or the Q&A box. Now is a good opportunity. I'm going to start with my own question that was asked last night at Advanced Care Planning. Brian, do you know of any or maintain any lists of common medical procedures that people may want to talk about in a living will or with a power of attorney?
We do. We have some fairly common language because we do get similar questions from client to client. Though I should say we can and often do personalize that document in response to and in conversation with a client to discuss, what procedures they would or would not want to have happen. Now, some of the more common is intubation, either assisted breathing or assisted feeding. Those are two large ones that clients do have opinions about. And then the language as to, life assisting measures speaks to it either in more general terms, and we do encourage our clients to speak to the people that they are naming as their agents. That's a very important thing because that document is that authority grant to the listed agent to communicate that to the healthcare professionals. So for them to have a good sense of that is very important. But that's another thing where the healthcare professionals are going to want to see the document, and they're also going to want to, well, to be perfectly honest, they're going to want to know that they're not going to face consequences over relying on either the word of the agent and or the document itself.
We have a couple of questions from the audience about power of attorneys. C asks, how many years is too old for a power of attorney document?
Oh, great question. Okay. The answer to that is that I have actually crafted and in one of the very first plans I put together for our family, I put documents together for our children. And so think back on the scenario that I painted. My wife and I have gone to Hank's Oyster Bar and now we're asleep, let's say for 12 hours. And the children are, in the care of, let's say, grandma, where we don't have a problem as to, sure, grandma has authority to hang on to the kids for at least that amount of time, though that's another issue, isn't it? But Sage and Morgan are play fighting. Somebody takes a little tumble, as they do. There's a medical emergency that is perhaps doesn't rise to the level of very serious, but it rises to the level of emergency room. If we have put together a healthcare power of attorney for both children, listing grandma and other typical caretakers, then that's a very, very good way for those medical professionals to know, yes, we can rely on grandma's word for any choice of care, situations. Think about that from that angle. You're giving healthcare power of attorney to, a 2-year-old, a 3-year-old. Now, of course, that child cannot sign the document. This is a grant from the parent who signs this document on behalf of their minor child. Essentially, from 0 to 18, one would assemble the document in that fashion. And then 18 and up, you're talking to an estate planning attorney. You should have something at all of those ages. I understand, I'm speaking both as an estate planning attorney recommending that, and also somebody who did not have that in place until our children were born. So I understand that. If you are here, at this presentation, you presumably understand the importance of that. Yeah.
I think what C was trying to get at is if I make a POA today, naming my husband, and 10 years from now, or 20 years from now, or 30 years from now, he needs to use that power of attorney, will there be an issue that I made that today? Do I need to reaffirm that or make that again, even if no circumstances change?
Excellent clarification, and that's a great point to make. Our general recommendation is that the estate plan be reviewed round about every 5 to 7 years, and or shorter if something has changed. To get a little bit more specific, and I'll use, Hannah, the scenario that you painted. A healthcare power of attorney grant to a spouse, that is largely going to be very reliable for as long as that person is the spouse, essentially. That is not something that is going to give concern to a healthcare provider, essentially because some of those powers exist by virtue of you being a spouse. If to change that scenario a bit, maybe we're speaking about somebody who is not married, who has granted that healthcare power of attorney to a trusted friend, who is who lives nearby, and which is a wise thing to do. This is a person that can be relied upon as both a friend and as somebody that is proximate. Now, those things change. Let's say it's not the friendship that changes, though that does too, but somebody has moved. That can present a challenge. Now we're not even really talking about time being a factor, but changes in life circumstances, which also impact when one should revisit a plan like that. But it seems that the question posed speaks more to that time frame. How long are we going to be concerned about? Inside of 10 years should not be a concern. And here, if we're talking about healthcare power of attorney, actually a longer time is fine, because a healthcare provider just kind of wants to see that you granted this power. On the other side, If we're talking about somebody carries a general power of attorney into a bank and says, here, look at this document that was signed 25 years ago, I'll take $500,000 from this account, please. That bank is likely to have some questions. And so here we would want to revisit that round about 10 years. Though, again, if we see clients at more like a 5 to 7 year range, we like that.
Carol has the question about the difference between a durable power of attorney and an existing power of attorney. Can you sum up that difference?
Sure, that's they're sort of operating in different realms there. Existing power of attorney means this power of attorney is of the type that when I sign it, it is in place. So existing power of attorney is the term that we contrast to springing power of attorney. Existing power of attorney comes into play as soon as I sign this document. Springing power of attorney comes into play when and if I am incapacitated. So those are the two phrases that operate as opposites essentially. Now, durable power of attorney is a title that we give to it in that it lasts. It does not mean the same thing as existing power of attorney, but that speaks to the force, the durability of this power grant.
We have a couple of great questions from Elizabeth. Elizabeth writes, if you become permanently incapacitated, would your successor trustee take over from your financial and healthcare powers of attorney? Any suggestions for someone who is aging solo to find companies to act as powers of attorney or as a successor trustee?
That is an excellent question. This is actually a great transition, though I don't want to cut off any other good questions. Though I'm looking at the time, we probably will want to move on into the next part.
If I didn't ask your question now, I will ask it at the end. So feel free to keep sending those questions in, and I am saving them if I haven't asked them already.
Right. Elizabeth asks about the power of the trustee in this situation. We haven't discussed trusts just yet, but it is the very next slide. So Elizabeth, excellent instincts. This is exactly where I wanted to bring the presentation. I am going to come right back to Elizabeth's questions after I define the trust so that we all make sure that we're understanding this transition and what in the world a trust is. I like to use the metaphor of the little red wagon. Again, it could be the dad in me, but essentially using the little red wagon as a metaphor for a trust, I find to be a helpful way to define it. The true definition of a trust is that it's a three-way agreement, essentially between yourself, and yourself. And I'll get a little more specific there. You are the grantor placing items into a trust that exists for the benefit of you. And the person who is in control of this trust during your lifetime is, once again, you. Now let's transition to that little red wagon. Essentially, that's the metaphor for that three-way agreement. If you have stuff, assets, that you want to carry around, you might use that little red wagon. You as the grantor would place things into that little red wagon. Who is that stuff for? It's for you. The stuff that you put in the wagon is for you to use. And who's in control of it during your lifetime, your capacity? It is, once again, you. Now, the nice thing about the living trust is that during your lifetime, you get to carry that little red wagon around. Everything that's in there, you can freely put more things in, take them out, use them. And that is one of the big benefits of a trust. But another thing is that it can handle incapacity. And let's speak about incapacity as incapacity that comes but also goes. Let's talk about, again, my wife and I at Hang Oyster Bar. We are in this deep, deep sleep. Let's say it's a little bit more serious. There are some side effects, and we go into essentially sort of a 1-month coma. That is bad, but we are going to recover from it, the doctors assure us. But during that time, those assets, any assets that we placed into that trust, can be accessed, not by us. As the trustee, we have lost capacity, and there's a clause in there defining that, and another clause saying who are our successor trustees. And when we have been found to be incapacitated under the definition of that trust, the successor trustee then takes over and can use those assets, again, for our benefit, because the trust is defined that way as well. But essentially, somebody still has control. Now, there's a third line there: a trust can replace probate, and it can handle incapacity. I'm not going to speak to probate just yet, though presumably folks came here with some questions about that. I am now going to return to Elizabeth's questions. As you see, they were excellent transitions. Elizabeth is not a plant, I promise, but I could not have set up a better question if I had tried. Elizabeth asked about the trustee and the power of attorney. There is some overlap here where a trustee and a power of attorney, an agent under a general power of attorney, would have some overlapping roles. One of the limits of the trustee is that they would only be able to have control over those assets that have been funded to the trust. That's a fancy term for they've been put into the little red wagon, meaning if I have a bank account, but I never went and put that in the name of my trust, well, then the successor trustee cannot control that asset. If I put together a trust, but I never funded my real estate, my home, to the trust, then the successor trustee cannot control that. Neither sell it nor exercise any payments to it, that kind of thing. Whereas the agent under the general power of attorney can, though we just spoke to some of the limits over the general power of attorney's control. Optimal scenario here, you have put together a trust and you have funded your assets to the trust. And here at our firm, we take strong efforts to really speak with our clients about all of their assets and let them know what should be done with this asset, what should be in the name of the trust, what should be listed, what assets should have the trust listed as a beneficiary to the trust rather than funded to the trust. This is true of a lot of assets so that they don't trigger a distribution when you move them. But those are sort of that's that interplay between the power of attorney and the trustee. To Elizabeth's question about how about naming a successor trustee as an institution, and that is something that we do counsel clients through. There are several bank and trust companies that do that, and we do have some referral sources that we do point out for clients, and several that do a very good job of that. And so this is that area where we are speaking to that interplay between the power of attorney and the trustee, Here is another place where I will say the trustee has some benefits that the power of attorney does not. We spoke to institutions that would be potentially hesitant to rely upon a power of attorney. It's a very important document. Again, we do not put together plans without powers of attorney. But a 6 to 7 page power of attorney versus a trust document which is dozens of pages, and it does tend to convey to an institution this person put a lot of thought into how they would assemble their estate plan. These folks that they listed in this trust as successor trustees to have control over the assets that they've funded to the trust. We believe that we can really rely on this document and this person listed as the successor trustee. Additionally, if we were to compare, say, the sale of real estate, a home that has been funded to a trust, and that is something that, well, generally speaking, realtors, title companies, buyers and sellers know that this is something that folks do with their homes. They fund them into trusts. And if somebody has put that thought into that process, said, I'm going to form a trust, I'm going to retitle my deed funding my home to the trust, or in the case of spouses, funding our home into the trust, having a successor trustee who can sell that home, a title company would know we can rely on this. Whereas, somebody listed as an agent in a power of attorney from 10, 15 years ago, okay, take my word for it. These folks are incapacitated and I'm going to sell this home. They're going to make some phone calls at the very least. Well, let's take a look at what comes up next. The other benefit of the trust is that it can essentially be a probate substitute. Let's again start by defining that. Probate actually comes from, I was a Latin nerd, yes. It comes from the Latin root word to prove. What do we do with a person's stuff when they have passed away? Well, we want to prove what it is that they intended to have done with their assets, their belongings, and that is the probate process. It handles your assets when you cannot. It is typically a will, although we're going to speak to intestacy, which is essentially somebody does not have a will, and there is an intestacy statute. State by state, there's a statute that says when you don't have a will, essentially this statute is the will. It's very typical to what we might imagine. Everything, it's kind of called the sweetheart will. Everything to my sweetheart, meaning spouse, in the absence of spouse, goes to children. In the absence of children, it goes up the heir tree, and so on and so forth. Little differences state by state, but largely that's it. There are time concerns, cost concerns, and privacy concerns when it comes to the probate process. I'm not here to give a horror story about it, but essentially it can take longer. In fact, we want it to take longer. We want to be sure that assets are going to where a decedent intended them to go. There are costs associated with that process that varies from state to state as well. And there are privacy concerns. The probate process is officially a lawsuit against yourself. Again, not to cast that as a horror story, but essentially we are trying to prove that the assets are going to where they should go, and that is that process.
We have a clarification question.
Okay.
Monique would like to know if the probate process takes place where the real estate is located or the state where the person lives.
Oh, the answer is yes. And I'll clarify that, but a great question. So this is another area where we often advise clients who might, for whom those answers are different. I reside in state A, I have real estate in state B, or I have real estate in states A through Z. Congratulations. But essentially, we are going to have to open a probate process in every state where you own real estate and or some other deeded property, a timeshare. But you're certainly going to have to open a probate, a probate process where you do reside or where you did reside when you passed away. And so that's a great question. When you have a primary probate in the state and county where you resided and where you passed away, that will be the primary probate, and any other place where there was deeded property will be an ancillary probate. Again, to my simple answer, yes, both, or multiple if there are more. However, to go back to our prior slide, the trust can act as a replacement probate. If you did have all of your assets and, most importantly, that real property, that deeded property, properly funded to the trust, meaning in the name of the trust, it is held by the Brian P. McAvoy Living Trust, Brian P. McAvoy as trustee, and any other successor trustee that communicates that essentially places it in the name of that trust with control over that real property being the trustee of that trust, me while I'm alive, but any other successor trustee after I've passed away or when I'm incapacitated. And so if I do fund all of my assets to that trust, then those assets are going to be distributed by the terms of that trust. That trust lays out who gets my stuff after I have died, to put it in the most basic terms there. That is what the will says, right? Well, the will says that when you have passed away. This is sort of that mirror image of the powers of attorney. Powers of attorney are in effect while you are alive, but only while you are alive. The will says what to do with your stuff after you have passed away, excuse me, but only after you have passed away. The trust spans both of those. Okay, and that's a really important thing to understand when we're speaking not only about the estate planning 101, what happens to my stuff after I've passed away, but estate planning 202 here. What happens to my stuff when I am incapacitated? So it speaks to both of those questions. Your trustee, your successor trustee, can control those assets if you are incapacitated temporarily, like our Hank's Oyster Bar hypothetical, or after you have passed away. Now, about wills here, I spoke to the sweetheart will. The Intestacy Statute in most states works essentially that way. Everything to my sweetheart, my spouse, absent that to children, and so on and so forth. What's in the will? Well, the directions as to what the, where the assets should go. Sometimes the, guardian nominations will be in there, if there are children. But what isn't in the will are any of those power of attorney, designations. Again, because powers of attorney are in force when one is living, and not after someone has passed away. We do get a lot of inquiry calls about, I was named power of attorney, for my brother, but my brother has passed away, and I want to make sure his assets are distributed properly. Well, that power of attorney holds no force now, and so it is not. A power of attorney is not a will, and a will is not a power of attorney. Whereas a trust acts in both of those capacities to some extent. I have questions written down there at the bottom, but I think that's because I shuffled around some slides. So sorry to get your hopes up. I promise I will address the questions in closing though. We also put a little slide in here to speak about estate planning during COVID-19. We have absolutely seen and received a lot of inquiries. It's the type of thing that calls to mind what happens if something happens to me. There are several life events that do call that to mind. For my wife and I, it was the joyful moment of welcoming a child. But many of us have seen loved ones in declining health. That's another one. Or somebody who has passed away, and yet another one. Another happier one is when somebody's going on a trip. Sometimes people think about it, what if something happens? But absolutely, this has been a scary time and something that, your estate planning attorneys have been living through as well. One of the challenges in this realm is that this is an area of the law where original signatures are still the operating rule. That is shifting, and in fact, this is causing state legislatures and courts to revisit that. It was a major topic in our most recent annual seminar, which this year was a remote seminar, as so many things are. But the likelihood is that if one did execute a document via remote signature, say a will, though technically our laws, say that must be an original signature, a court would likely recognize that, but we don't like to deal in the likely. We have gotten good and creative in making sure we get documents signed, whether we need to do an outdoor signing where the research tells us that that's a safer environment, or whether we have a side entry to our office that leads into the large room, so that we can respect social distancing, wear masks. But the good news, as you see at the end there, most of the process, other than the actual signing, can be done remotely. And so we work everything from the initial consult to follow-ups, and estate planning attorneys have been getting more and more creative in that, but essentially we've been moving in that direction already. That is something that as a field we have been working through. Well, here's our little summary and outline. We spoke to powers of attorney, both general or financial, however they're referred to, and medical powers of attorney, / the living will or advanced medical directive. We spoke to trusts and how those can work in some of the similar ways as to powers of attorney, but also into the realm of where a will would operate, which is after death, and in fact take the place of probate. And we spoke to wills as well, what they do cover and what they don't, and a little bit about planning in the COVID-19 era. I will be taking some questions, but I will do the closing first this time. And so I do want to say thank you very much once again. There's the whole family. I do need to get some more recent pictures in there, but that was a good old apple picking trip. And you see at the bottom there, my email. Feel free to reach out, and I would be happy to hear from anybody. So once again, thank you so much.
Thank you so much, Brian. We do have some questions from our audience. I'd like to start with Jerlonda, who goes back to our conversation about powers of attorneys when you mentioned a bank may not accept a 25-year-old signed document, but my spouse being my power of attorney is more endurable. She asks, what institutions are most likely to not accept a general power of attorney? And I'd like to tack on to that question, are there specific circumstances in which you see powers of attorney being declined more often?
Right. I spoke to where we see limitations, and that is a real estate realm. It can be done, but we would draw up a very specific power of attorney for any real estate sale. And this is done in the realm where, somebody is, say, abroad. Members of the military often do that to give somebody authority of sale. So that is an area where, especially, a buyer does not want to come to the realization that the person selling them the property did not have the authority to do so. So that is, that's perhaps a layup answer, but that is the answer. That is the realm where, institutions or individuals are going to be very skeptical about a power of attorney. Scenarios or institutions, it's one of the areas where we were just dealing with an institution today that was just being very difficult about a stock transfer. Now this was after somebody had passed away, so this isn't where we're speaking to powers of attorney, but I give that example to speak to every institution can be its own challenge, or they can operate exactly how we want them to. We design our documents to be broadly applicable in that sense, and that is also an area where it's helpful to have a law office to be able to call up and say, no, we drafted that document. You can go ahead and rely on that. But it can just be, a particular branch being difficult, a memo that went out and somebody's a little nervous to rely upon a document. A good, well-drafted, recent document to clear about the authority grant, and in fact, getting very clear about I give control over my financial assets. I give control over my digital assets. We've gotten more and more explicit about those power grants. If the document can be drafted that way, you can head those challenges off at the pass.
Continuing on with powers of attorney, C asks, I've been trying to explain to my 87-year-old mother the need for a power of attorney, but she does not understand that need. How does an attorney decide if the person is too limited in mental capacity to sign for a power of attorney?
That is absolutely a challenge. I'll give some of the easier answers before I kind of drill down on the very core of that question. The easier answers are, this is why we try to get them done earlier in life, and I know that's not the question, but that is one of the approaches that we take. But as we approach that declining mental capacity, when we are assembling these documents, there are, I won't get too much into the weeds, but there are differing levels of required capacity for testamentary capacity, right? The requirement to, to form a will, a last will and testament, versus contractual capacity. As basically as a legal society, we want people to be able to grant that power of attorney, and that is a slightly lower bar to clear. There are typical questions that one would ask. Those general, what day is it? What month is it? Can you tell me the date? Can you tell me who the president is? Is this, that kind of thing where, are you aware? And then, when we move into wills, we ask, what are your belongings, and, can you name them and what you want to have done with them? And that's even in case law where capacity gets challenged. And it can be, as anybody who's experienced a friend or a loved one in declining mental capacity, that can come and go. And so we can and should look for one of those good days or good moments, however this person seems to be experiencing that. So the lucid moments, sometimes they can be anticipated, sometimes they cannot, but to be able to capture one of those moments and be able to craft the document in that time is what one would do. But it can absolutely be a very difficult time.
One more question about power of attorneys before I move on to trusts. Elizabeth sent in a follow-up. She said, thanks for confirming that there is some sort of overlap between agents and successor trustees. I'm more concerned about having someone advocate for my health care while incapacitated. I don't see how a bank would honor my health wishes. It would be easier to write a trust to block a bank selling my investments and moving them inside the bank. I think what she's getting at is she is aging solo. So for somebody who's aging solo and is concerned about having someone to advocate for them while they're incapacitated, what options does someone in that situation have?
Right. And that's a very good clarification. Essentially, there often can be and is overlap between the fiduciaries named as fiduciary, meaning the person responsible, in your will, your trust, your power of attorney, your general power of attorney, your medical power of attorney, but it does not have to be. And in fact, it's very common to see different names, particularly in that medical power of attorney. So a very good, Elizabeth, another very good question with a very good answer. And that is, do think very hard about that person that you believe both knows your healthcare wishes, and that you believe would be able to advocate for those wishes. Oftentimes that's family, but doesn't have to be. And really, the family is a much lesser determining factor than the answer to those questions I posed. Is this a person who knows your wishes very well? Though that can be remedied, you can speak to that person about that. Perhaps more, that second question, is this a person who can advocate for you, who out of their, concern and care for you, can and will advocate on your behalf when you have made clear what your wishes are. So no, that absolutely does not have to be the person named as your executor in a will, if any. You should have a will, sorry. Executor in will, successor trustee, if any. so those can be different names, the person named as executor, the person or people named as successor trustee or trustees, and then general power of attorney, medical power of attorney, healthcare power of attorney.
I'm going to put this out there because I think that there might be a person either in our audience or who might watch this later on YouTube and have this thought. I am a person entirely on an island of my own. I have no friends or no friends that I would trust to act in this situation. I have no family, truly, or at least no family that I would trust to act in this situation. Is there someone I can hire to be my healthcare power of attorney? Does that exist?
That's a tougher one. Essentially, almost all of the other roles are positions that can and often are filled by institutions, by bank and trust companies. The healthcare power of attorney, again, one of the things that I spoke to earlier in the presentation is, is this about advocating for your health? Yes, it is, but the reliance upon this document is also there for the healthcare provider. Will that healthcare provider feel comfortable saying, yes, this is a person advocating and giving the wishes on behalf of the person who signed the document. And if I do what they are telling me to do, I'm not going to get sued, right? And this is another one of those areas where, officially speaking, the healthcare power of attorney is a list of wishes and a person advocating for those wishes rather than, a contractual operation. And so, the short answer here is no, not really. No, not really. Go try to get a friend to do this, even a friend you haven't spoken to in a long time. Start that relationship and get to talking about those, those wishes that you have. This is somebody that, preferably you have a relationship with, and that will be able to not only speak to those wishes that you make, but have a good sense of them. So yeah.
And barring that, I would say speak with your healthcare provider and see what they recommend.
Yeah.
So now I would like to move on to questions not about powers of attorney. The first one is from Rosinda. I live in New Jersey. Should I have a lawyer that practices in New Jersey, or does it not matter where that lawyer practices?
It's the former. Yes, you should have an attorney licensed in that state.
What if she hires an attorney in New Jersey and then moves to New York?
Yes, one should then speak to a New York licensed attorney as well. We are in a geographic area here where, we're sort of we even call it, right, the DMV, right, the District of Columbia, Maryland, Virginia. And I am licensed in all three jurisdictions, and several of our attorneys are as well. And I can rattle off several just very quick differences from state to state, or in fact, only one of them is a state, right? One, the state of Maryland, the Commonwealth of Virginia, the District of Columbia. And so even just in what we call them, they're different. But more to the point, the operation of laws are different in each. I grew up in New York. And I happen to know just by counseling my parents through, making sure that they had their estate plan done. We made some updates in consultation with a New York licensed attorney, but absolutely. And some of those differences are the impact of state estate taxes. There is a federal estate tax, but there are also state estate taxes. That can be a difference. The form language, the required language in some of these documents are different. And so, yes, the answer is a very, very certain yes. one should consult an in-state attorney.
Thank you for that answer. Our next question is going to be from C, who asks, does one's total assets determine if one should have a will or a trust?
Total lawyer answer, here it comes, maybe. But mostly that is certainly something that we speak very, very prominently to in the consultation, though obviously we go beyond that. There are multiple ways that not only the total amount of assets, but the nature of the assets impact the way that the estate plan should be assembled. Nature also speaking to, like we spoke about, real estate or deeded property in multiple jurisdictions. That's a very strong consideration for putting together a trust, because that can avoid having multiple probate proceedings. And so another one, of course, is total assets, where currently the federal estate tax is at a level where one does not trigger that unless one has an individual estate assets in over the $12 million range. A married couple can combine those, and we're speaking to the $24-25 million range. However, the sort of joke line from estate planning attorneys is that we can't tell you two things. We can't tell you when you're going to die and what the estate tax regime is going to be when you do. That is something that might shift should we have a new Congress, speaking not to politics, but to the fact that these things change. Additionally, speaking to the state estate taxes, the state estate tax in Virginia is 0. There is none. Whereas in Maryland, they have mirrored the federal estate tax. So it's essentially the same. And whereas in DC, they just moved the exemption level down, meaning an asset level of I believe it's at 5 million triggers the estate tax. And so that is one of those areas where we speak very prominently to what are the assets, how many are they, and what are their natures, and should we put together a trust now, and what kind of trust should that be? Estate Planning 303 might be about that, but that might be more like 505. But essentially, that's a very prominent factor in estate planning. Yes.
Thank you. Our next question comes from Deb, who asks, are trusts typically paid yearly for the length of the trust, even if it is a family member?
Are trustees paid? Is that the?
Yes, trustees. I apologize.
No worries. Yeah, sure. During the lifetime of the grantor, meaning it's still you, right? It's still you that put the stuff into the red wagon, and it's still you pulling it around. There is no payment. This is essentially the trust during your lifetime is you. The identifying number of that trust is your Social Security number. That trust does not go and get its own number, which in this case is an EIN, an employment identification number, until and unless the grantor has passed away. The successor trustee is entitled to compensation in the way that the trust essentially says. That can be a bit of a default provision of, quote, reasonable compensation. And reasonable compensation is usually laid out in each state's statutes, and the trust itself will dictate, this trust is governed by the laws of state X or Commonwealth of Virginia. And so how that payment works is essentially, in that manner. Now, if a trust is just pretty much a probate substitute, I have adult children, this trust is going to hold my assets while I'm alive, and when I pass away, equally 50-50 to my two children who are adult children. Essentially, that successor trustee is just going to do that, and that's the end of it. The compensation will be for that time period, which sometimes takes some time, again, depending on the nature of the assets or the amount or that kind of thing. It would not necessarily be an ongoing payment, system. Whereas a trust, well, say in the, in a family like mine with young children, those trusts that actually are, my trust document gives rise to, go on not only until my children reach adulthood, legal adulthood, but actually even beyond that, which again is a customization that one can do in a trust. That successor trustee for those trusts given rise to under the trust document would be serving for much longer, and compensation is a much bigger factor. This again will be covered in our estate planning 505, but you can see how this is something that, yes, can get quite detailed.
Walter asks, can a will and a trust ever conflict? And if so, which one would take priority?
A very good question. And I spoke a little bit more to this in Estate Planning 101, where I spoke about how a will and a trust should be designed side by side to work in concert. What we put together whenever we put together a trust is what's called a pour over will. Not pour over as in read closely, but if something happens to pour over the sides of this trust that you have put together and drop into a probate proceeding, that will says, I put together a trust. Hey, probate court, send it on over to my trust, and it will be distributed under the terms of that trust. And so that is how that problem usually does not arise. Theoretically, if one has put together a will that has certain terms of distribution, I want things to be distributed equally to all of my children. Whereas you put together a trust that says, actually, yeah, my oldest child, she's done very well for herself. I love her dearly, but I have made no, I have intentionally made, no arrangements for my oldest child, which we see in some documents. The answer to that is that anything that's funded to the trust will be distributed under the terms of that trust. Anything that is not, anything that is a probate asset will be distributed under the terms of the will. Now, one could put a petition before the probate court, see what a judge makes of it, but essentially that's the presumptive course that those assets will go. Mm-hmm.
All right, and our next question comes from Lyndon. What is the difference between a conservator and a guardian?
Right. Essentially, the difference there is guardian is guardian of the person. Conservator is the guardian of the assets, for lack of a better phrase. That's the major line of delineation. That is not an area that I practice in, a whole lot, but those are the different shapes of those terms, and it's very common for when we have a guardian appointed over an adult person who is mentally disabled, then that might be what is structured, a guardian of the person and a conservator who might or might not be the same person. And in fact, it can be a good system to have two different people named, but that's the line of demarcation.
So that was actually our last question, and I have kept you longer than we said we were going to go, so I apologize for that, Brian. But thank you so much for being here tonight. Before we end for the evening, I just want to say another thank you to the Friends of Duncan Library for making programs like this one possible. You can find them online at friendsofduncanlibrary.org. Our next program that I'd like to tell you about is going to be a home buying and selling program. If you want to learn more about home buying and selling in today's market, a realtor, a loan officer, and a financial planner will join us on Saturday, October 24th at 3 p.m. That is going to be a meeting style program where people will be able to unmute and ask their own questions. I also want to let everyone know that I maintain a death literacy guide on our website. My death literacy guide has information about all sorts of death-related topics, including estate planning broken down by state. We have state resources for Virginia, Washington, D.C., and Maryland. We also have resources for grief, funeral planning, end-of-life care, and just general interest about the topic of death. I run a monthly death cafe that you're all invited to. My email is in the chat box. It's hrisley@alexlibraryva.org. I am more than happy to put you in touch with Brian. I am more than happy to give you more information about any of the resources I listed here tonight or about upcoming programs. So feel free to always reach out to me. Brian, did you have any final words for us tonight?
No, I want to echo some of the sentiments. Again, thank you so much to all of you for being here. Thank you so much to Hannah and to the library. And please do reach out if you've got some questions. I know email is a little difficult to read there, a blue on a blue background. That was probably not the best selection on my part. I'll change that. But thank you again, and I'd be happy to hear from you.
All right, thank you everyone for joining us tonight, and thank you so much, Brian, for this great presentation. The recording of this will be on YouTube for a few months after the conclusion of this presentation, so if you need to revisit it, just reach out to me. I'll send you a link. All right, everyone, have a good night.
Thank you. Good night.